In the country's history, no one had ever directly filed a case challenging public school segregation. Marshall was on the lookout for a case outside of the Deep South, where he felt NAACP lawyers had a better chance for success with open-minded judges and juries. But in the meantime, there was Clarendon County, South Carolina. The disparities between white and black resources in Clarendon County's school district number 22 were indisputable. The district served a rural community that was 3/4 black, but the county's white students had brick and mortar structures that were well-maintained grounds and modern facilities, while the black students took classes in dilapidated wooden shacks with no indoor plumbing and were forced to get their water from a community well and use outhouses no matter the weather. They had no buses, and some black students had to walk up to 9 miles to school. To Marshall, Clarendon County was the perfect opportunity to litigate for equal facilities, transportation, and other resources for the county's black children, but it would be foolhardy to push for full segregation. Marshall knew that he had slim odds of winning a victory in South Carolina, and he understood how dangerous a legal challenge would be for the case's plaintiffs, who would bear the full brunt of white supremacy's retaliation for daring to challenge for integration. Marshall's hand was forced, however, by a surprising Judge Watts Waring. Waring was a white Charlestonian who actually supported civil rights. Waring, who was past retirement age by 1950, was ready to make one last judicial strike against America's segregated education system. Marshall arrived in Clarendon County ready to argue Briggs v. Elliott in 1950. The suit had come in the name of lead plaintiffs, an Army veteran Harriet Briggs and his wife Eliza Briggs, who was a maid at a local motel. But Warren challenged Marshall to refile the case as a direct attack on the constitutionality of segregation. The new suit would claim that separate but equal opportunities, even if materially equal, were in denial of Briggs' plaintiff's 14th Amendment rights. Neither man was under any illusions that the case would succeed. Losing was inevitable, but Warren argued by bringing this challenge up in federal court, a loss would guarantee a hopscotch over the U.S. Court of Appeals and place him directly on the Supreme Court docket. The stakes were immense. If the NAACP were to lose its appeal before the highest court in the land, Plessy v. Ferguson would be reaffirmed, and decades of meticulous work would be lost. Maybe like decades more before another opportunity to challenge segregation would lead on. Marshall was conflicted but decided to push forward with Warren's plan. Briggs v. Elliott was now heard before a 3-judge panel, including Warren. On May 28, 1951, the school district's lawyer attempted to upend the trial with a surprise announcement. Clarendon County's fully acknowledged